afternoon, Miss Kenney. How are we doing today?
We are good. So Jill, I think Terry kind of set up a perfect entry for us to discuss what happens at 18. So certainly, why don't you get us started?
Well, I guess Michelle has a wonderful presentation that I know is going to be forwarded to all of you, which says when being mom or dad stops being good enough. And I know that the previous presenter discussed, living in mom's house and mom and dad really not having control over their child. Ashley is now an adult. So what happens at 18? And unfortunately, there were so many different ways of going about things. And there's a lot of different options.
Well, Jill, before we go any further, this is my own soapbox, and it's important to me, and Arlene was a very dear friend and mentor, and I think she would support this as well. I know our title talked about guardianship and guardian advocacy, and I really just want to make sure as a community we kind of flip that around and we talk about legal options and what those might look like. So I think for you and I want to talk about what some of those least restrictive options might be that keep us out of the court system. And then you to talk about guardianship, which is our more restrictive option, and why, once you understand why it's so restrictive or how it's so restrictive, then I can kind of come back in and talk about guardian advocacy, which I know Martin said is kind of like a guardianship light. But I think what we also have to appreciate is there are a lot of families that sometimes choose to do nothing because I think there's a certain fear or just even being overwhelmed with the day-to-day. Certainly when you start thinking about all those transitions, and this is just another one of those, that they become paralyzed. And so I think what's important to me, and I know it's a passion for you as well, is making sure that education gets out there early, and transition starts at 14. So even though we might be talking about things when the child's turning 18 or even 17 and a half, depending on who you talk to, as far as an appropriate age, it's never too soon to at least have the education about what legal options exist and where you might see your child kind of evolve on, the range of the different options that are available, so that by the time they're 18, you're not left paralyzed and you have a direction and you have a kind of way to move forward. And so it's not something else to just add to your plate, but rather a box you can kind of check off and move on. I know you and I both see a lot of families where they're stuck doing very reactive planning, where it's that hospital and it's in a situation or it's a school. Somebody telling
cutting you off for 1 second though, because one thing as a guardianship attorney, and then you're going to go back to talking, you need to plan at 14, 15. Don't come to me at 17 and a half and start telling me you need no. And Michelle's going to go into why it's so important to really plan early and to educate yourself early. Okay, off soapbox, back to Michelle.
Or I was going to say, more importantly, it's the phone call on a Friday afternoon like this, where the parent says, well, my child's turning 18 this weekend. What do I do? And I'm going, there's only so much we can do that quickly. So, I think once everybody understands the court process and just, where those pitfalls might be, to really focus on proactive planning and not reactive planning. And that's certainly something that I know is important to you as well. So with that, let me talk about some of those kind of least restrictive options, and then let you take over with some of the guardianship pieces and why that's kind of such a big deal to try to avoid if we can. I know we're talking about guardianship attorneys telling you not to do guardianship, but I have always said good guardians don't do it if they don't have to. So, just remembering that we want to try to avoid it, but it is something that we have to protect children that obviously can't do that self-advocacy. So Jill will fill you in on the good, bad, and ugly of that. But where I want to start is basic estate planning documents, and also the discussion about supported decision-making, which Terry might not have used those words, but that was really what she was talking about when she was talking about self-advocacy, is making sure that we've given someone the tools to make their own decisions, but in a supportive environment. And we all do that as adults. When we've got a big decision, we go to those trusted advisors and say, hey, what do you think? So supported decision-making is a framework where a young adult with a disability can do the same thing. It's normally a written agreement where they're spelling out exactly who those supporters will be and in what role, and when those supporters are going to step in. So, maybe certain decisions they're going to handle on their own, certain decisions that supporter will step in when maybe there's a pivotal point or a moment where they get stuck and they can go to those advisors. For estate planning documents, though, whether we're talking supported decision-making agreement or what most individuals I think are more familiar with are things like a durable power of attorney or a designation of a healthcare surrogate. Those are the sorts of documents where anyone 18 and older that has the basic capacity to understand the documents. And I say that because that doesn't mean that you have to understand all the legalese that's in it, but you have to understand some basic concepts that you're delegating your authority to somebody else and what sort of authority you're giving that person and under what circumstances. But if we can sign those documents, and I'm going to stand up and say everyone over the age of 18 should have those documents, because Jill and I and your next two presenters, we all know what happens when people don't do those documents and end up in a guardianship.
They hire me and spend a lot more money. Back to Michelle.
Yeah, well, but the reality is nobody wants their life before the court. So, this unfortunately, our developmentally disabled population is probably the only population that may not always have the advantage of doing that planning. All of us that are neurotypical should have those documents in place, because sometimes life happens and we want to make sure we've got an agent in place to handle our financial matters or our medical matters, whatever those might be. And those are the basic documents. Again, the durable power of attorney or designation of a healthcare surrogate, to name those agents to avoid a guardianship, assuming the documents are done appropriately. So there's nothing that says a young adult can't do those documents if they, again, understand the basic concepts. So that, along with a supported decision-making agreement, can a lot of times work to keep that individual out of the court system. Again, there has to be a basic understanding of the documents that they're signing, but it allows them the freedom to go and do that self-advocacy and make those decisions for themselves, which I think is also an important distinction to make, Jill, that we're allowed to also make our own mistakes. I know that Terry was talking about being a helicopter mom. And so I think sometimes parents get a little scared. Well, what if my child makes a mistake? Well, that doesn't mean we take their rights away just so they can't make mistakes.
I make mistakes. And in that case, we're going to have a big problem.
But that's how we learn. That's how we grow. That's how we develop those skills. So I think it's that balance between protection.
I agree with you.
And a certain amount of risk, and allowing that person to be independent. So if we can use estate planning documents, that's normally where we're going to start. Certainly as attorneys, we're going to at least evaluate for that piece.
Wait, and let me just stop you also. So you'll hear estate planning documents, advanced directives, living will, power. These all are the same thing. They're basically documents that assist you during life and also at death, but assist you to have other people act on your behalf.
Right. And I was going to say, depending on the attorney, they might have a slightly different name for the document, but right, whether we're talking advanced directive, something you're doing before you hit that crisis. So you've got those sorts of things in place. The other things that are maybe don't come to mind as quickly, but things like being the representative payee for Social Security. So you can obviously go to Social Security and apply to be the payee for someone with a disability without having to go through the court system. So, those are the sorts of things that we have certain things to, help somebody manage their benefits without going and taking those rights away. Things like joint bank accounts, even, as a way to help someone manage their finances. So we always have to just start with what are those community supports? What are those legal documents that we can use? Because if we don't, then comes guardianship as our more restrictive option. So Jill, I know this is something that you can talk about, all those nuances about why we don't want to do it. So I'm going to let you take over for that.
Well, I think before I even want to get into that discussion, I think you and I need to discuss what are least restrictive alternatives. What does that word, what do those words really mean? We hear them all the time, but what a least restrictive alternative means is, and this is a guardianship attorney talking, you really want anything but a guardianship. And obviously I'm going to explain to you that in a minute. But if you listen to Michelle and you listen to all the people who came before me, they educated you on ways to be able to avoid guardianships and to take care of your children properly, which is really what we want to do. Now, obviously I'm calling them children because they're still your children after they turn 18. Now, I know I have furry children. I don't have real children, but with all of my friends with children, and many of them special needs, I understand what happens. They're still your child. My mother is 83 and I'm still her child. So,
and Mama Bear never goes away. It doesn't matter what age.
Understood. So you want to take care of your child in the best possible way. And the best possible way, really, number one, is if you can get documents, if your child will sign and they do understand, you know, a lot of people, you know, I hear if they're incapacitated, they can't sign. Again, just because your child has a disability, a learning disability, a mental disability, does not mean they are incapacitated. I have dementia clients that are capacitated because they understand what they're signing. And if you bring them to somebody and you explain them those documents, there's no reason why those can't be executed. Now, can those go awry? Unfortunately, yes, as we all know. As one of our judges like to call a durable power of attorney, the weapon of mass destruction. And we won't go into that today because it's not proper for this, but that's a whole nother discussion. But what is proper now is the guardianship discussion. What is guardianship? It's a guardian ad litem. No, it's not. Okay. What is
or I love the ones, Joe, where they say, well, I'm the guardian, and you ask them for the court and the case number.
No. Where are your
there's not a court case.
Where are your documents? It's you know, can I see your orders or your letters? You've got the blank stare. Okay, you know, well, I don't understand. I'm the parent, so I'm the guardian. Okay. No, you're not. And that's the unfortunate part of life in general and just the way our statutes and our laws work. And it's not just this state, it's every state. So a guardianship, a guardian and a guardian ad litem. A guardian ad litem is someone who advocates on someone else's behalf. So you're advocating and you're basically telling the court or whomever you're telling, that was weird, that you are making some type of decision on this person, but you're advising. You're not the one making that decision. You're telling the court either it's a settlement or it's a divorce case or it's a custody case where you're saying, you know, in this case, the father would be the best person because of this.
I think you see that a lot more in dependency cases, right? Yeah.
Now, but you will see them in minor guardianship.
Sure.
So, yeah, and we won't get it. That's a whole nother story. But in a regular guardianship, what is a guardian? A guardian is actually the person who steps in the shoes of the person who is the AIP, either the person who's about to be declared incapacitated or the ward they've been declared incapacitated. They are acting for that person. So it is actually substituted decision making. I hate that word, but that's exactly what it is. So when you are a guardian for someone, you are actually making decisions on their behalf. And it's a very, you know, I will say one thing, and I want to address the movie first about the whole guardian issue. The majority of guardians in the state are fabulous. Michelle and I represent and have been in the guardianship system for many, many years. 99% of the people you're going to deal with are on board and fabulous. Are there bad guardians? Yes, there's bad people in life too, though.
Well, some of those bad guardians are family guardians. We're not just talking professional.
Oh, no, there's bad guardians all around. There's bad, but, and how many wonderful family guardians do you deal with too? So, you know, the guardianship system in itself is not corrupt. Michelle and I can both tell you for Palm Beach, Miami, and especially Broward, that we have court monitors, we have judges, we have auditors. I have an auditor up I won't fill in the blank there, all of the time. There is virtually no way, and I'm not saying it can't happen, but there's virtually no way that you're going to be stealing money or getting away with stuff.
But Jill, I think that's the important distinction that we're talking about, is this is now a legal relationship that is supervised by the court on an ongoing basis. It's not one and done. And I think that's where sometimes parents get confused going, I'm going to go to court, I'm going to be the guardian, and then I'm done with the attorney in the court system. And no, the court supervises this relationship as long as there is an incapacitated individual.
You get Michelle and I until somebody dies or until they get restored. And that's something else I will discuss later, but let's actually get into the guardianship system. So what is guardianship? Guardianship, as Michelle said, is a legal relationship between you and the court where you actually file a petition. You file two petitions. You file a petition for incapacity and you file a petition for guardianship. Now let's start with the first petition, which is a petition for incapacity. So basically you are petitioning for someone's rights to be removed. Their civil and their rights are going to be removed. And you hear they're a ward of the state. That's exactly what's happening here. They are a ward of the state. The state and the guardian are both responsible for this individual, which means, like Michelle says, you are in the court system, and you are in the court system for as long as this is not a one and done. This is, you get guardianship over this person, and until you can prove that this person is capacitated, and I'll discuss that later, and you always want to try and do that because you want to get the person out of the system, or they die. That's the only two ways that you're getting out of a guardianship. There are slight exceptions to that that don't apply in this case, that could apply for Medicaid issues, but for regular purposes, that's the only two ways that you're getting out. So when you file that petition for incapacity, they're now going to send out 3 people to determine if that person is incapacitated. Now I get these, and Michelle gets, don't worry, the doctor already says they're incapacitated. Just no. It doesn't work that way. Or, I got it. We know he's incapacitated. Okay. I don't care if 17 doctors wrote, and they're Nobel Peace Prize winners, wrote letters saying that this person's incapacitated. Guess what? Doesn't matter. Okay. The only 3 people, and now obviously, Michelle, there's in litigation, you bring in people. I'm not talking about that. I'm talking the only 3 people that matter are these 3 people. It's usually a social worker, a psychologist, and a psychiatrist. And these people are picked by the court. It is random. They are vetted by each of the courts, and they are now sent out to interview the person who is about to be declared incapacitated. Now, how are they sent out? If it wasn't COVID, they would actually be going to the house and interviewing that person. It is extremely important for us to do that. Why? Because in many instances, there's somebody there who's either abusing or doing something to that person. And it could be in this case too. So you want to make sure that that doctor or that person going out there is independent. Now, obviously, these people do this all the time and they're hip to things, but you clearly want to make sure that the doctor is going out and interviewing that particular person or the examining committee member. Presently, during COVID, there is an option to be able to elect telemed, which is basically them interviewing the person over a Zoom screen like this, web. I mean, there's different ways of doing things. In most instances, we're going to elect that because if you don't, that examining committee member is probably not going out for another year or 2.
Yeah, I was gonna say, we can't go forward if they can't do the examination.
And you're not getting a guardianship for like another year or 2. Now, one thing I also want you all to see is how much time this is taking so far. So now we're getting that petition for incapacity. I didn't even discuss that whoever's applying, and we'll talk about the guardian later, is filing several documents that the court has to go review those. So now think about the months that are flying by, because that's exactly what's happening.
Well, Jill, if we were to ignore COVID, from the time of filing to the time of the appointment of the examining committee, and I know you'll still get to the court appointed attorney, you're still at least almost 3 weeks in.
Oh yeah.
So, and this is, we haven't even had a court hearing yet.
That's correct. And remember, that's also dependent on whatever judge having time.
So then
to
add COVID on top of that. And this is where, some things can be a little backlogged right now.
Yes. So you're filing that incapacity. Now we go the 3 examining committee members go out. Again, doesn't matter who else, just these 3. If 2 of the 3 committee members find this person incapacitated, and we'll get into the different levels of incapacitated in a second, that person under the statute is generally found to be incapacitated and is now considered a ward, and you will be able to get a guardianship. If only 1 comes back, then that petition is dismissed under the statute.
And Jill, I was going to say it the other way, if 2 of the examining committee members come back and say this person has capacity, then it's dismissed. It doesn't really go anywhere at that point. So, and these are supposed to be independent evaluations, although they can talk to one another, but sometimes they see things very differently. Sometimes they see it all the same.
And you will get very, very, depending on who you get to go out there. There are some, and that's unfortunately, you know, another nuance of having a guardianship is there's some fabulous committee members. There really are. I mean, I get the reports, I'm like blown away. I'm like, this is, wow, I've learned so much. And then I get ones like, did you really go out and see that person? What is
well,
this?
And there are also days where I'm having a good day and I'm having a bad day. So, you know, that's where you could have reports all over the place.
And again, that's just, you know, we're showing you why you are now beholden to somebody else, where I'm kind of a control freak and I know Michelle is too. And so if you try and do things ahead of time, and I'm not saying you'll always be able to avoid a guardianship, sometimes it's inevitable, but really trying to avoid this as we're trying to bang into you is really the best way to do things. So now we get to the hearing. I didn't even talk about my favorite person, the court-appointed attorney. So everybody gets a lawyer in guardianship. It's kind of like Oprah. Everyone gets a car. Well, everyone gets a lawyer in guardianship. So the person who's petitioning, whether it be a family member who wants to serve as guardian, and now we can also talk about professional guardians, where if a family member doesn't serve, there are people who are licensed by the state, and you can look them up. There's a list of people. And you can petition for an independent professional guardian to be appointed for $85 an hour in Broward and $95 an hour in Palm Beach. That is.
And Jill, to clarify, that money is generally paid from the assets of the individual under guardianship.
Correct.
If not, whether that's a pro bono case or it's being paid from another source,
well,
also a whole nother angle.
Well, I didn't even want to get into that.
I know,
right?
I know. But
one of the things
questions come up about money. I know that's an issue.
And we're going to discuss that also.
And you're already talking about attorneys, so we know there's money involved.
Well, well, when we get the lawyers involved. So yes, that money comes out of the child's money. But there are some times where I do have parents who feel it's so important that they do pay the professional guardian themselves. And that's, you know, sometimes you might not have the time. And while it could get costly, it might be more costly for you to do the work. So
I think some parents are also concerned because there's not other family. And so if something were to happen to them, they at least want somebody else that's going to know this individual, to know their child.
Which is also an excellent point. And sometimes you also have feuding family members, especially mothers and fathers. And sometimes it might be appropriate at that point to also have a professional guardian. So we get
back to attorneys, sorry.
Well, now we're getting back to the attorneys. That's back to the petitioner. And now we're at the court appointed. The court-appointed attorney is the attorney who gets to represent that person who is about to be declared incapacitated. The court-appointed attorney is generally, and I'm talking generally, someone that comes off something called a wheel. So I'm going to discuss Broward County, and Palm Beach is similar, and Miami is similar, where different attorneys apply. They are accepted by the court, and the court now puts them on a timetable, which is called the wheel. And let's see, it's April 23rd. So Michelle's partner, Alex Ryman, is up, and she is now the court-appointed attorney. So what does that mean? That means Alex got to go out. She has to evaluate the person who she's now representing, and she files a report with the court and there's all different ways that these attorneys act, because none of them do the same thing. Some of them declare everything. I'm not going to say anything, and I'm going to let everyone else talk. Some of them have a voice. It really depends on the attorney you get. That being said, your hearing's really going to depend on that person. It is unfortunate, but that person has a lot of say.
But Jill, isn't that attorney supposed to be representing what I might want as the alleged incapacitated person?
Absolutely, they should be.
Like a regular attorney-client relationship?
They should be. They should have a regular attorney-client relationship. However, as someone who has been doing this for a number of years, and as someone who has been against almost every single person on the wheel, I can tell you, unfortunately, that is not going to happen. You know, a lot of people ask me why I don't go on the wheel, because I'm a petitioning attorney. I don't think that I could do that. And that's one of the reasons why I don't do that. It's a difficult thing to be able to advocate and to be able to step in someone else's shoes. And that's what you have to do as the CAA. There's some really good ones on here. There's an excellent one on here.
There's one coming up next, I hear a little
who's
bit.
Coming up next
yeah,
who's
exactly.
Really excellent. Okay. And there are some excellent court appointed attorneys.
So Jill, the court would appoint an attorney for this individual.
That's correct.
So does that then mean that the individual is stuck paying for the attorney?
That is correct. That is absolutely correct. They get an attorney who they didn't ask for, and they get the privilege of paying for them too.
But we're talking about a lot of young adults that don't have assets.
That's correct. And
so then what happens?
Well, it's the court appointed attorney gets a certain amount of money from the state at that point.
Okay, so the state of Florida then is picking up the tab, and I'm guessing also for the examining committee in that case as well.
And they file an indigent report. Their attorney will know how to do that. They file I can't pronounce it because it's Friday afternoon, but there's an indigent report that they will file saying they're indigent, and the court will pick that up, declare them, and those courts will. There's a fee.
Okay, so parents should not be completely freaking out that if their child doesn't have the money to hire their own attorney and pay the examining committee, that they shouldn't be doing this, because obviously if the court finds that that child is indigent, then the state of Florida is covering that.
That's correct.
So, but I think the important point is we're taking this person's rights away, so they're entitled to be represented by an attorney.
That absolutely. I mean, that's, the whole point. I might, obviously I don't like the court appointed system. That's just my personal opinion, folks. But yes, I mean, they're entitled to an attorney. I feel that they have to have one because their rights are being taken away. And in a lot of cases, if the person is not contributing to the hearing, then their attorney is allowed to waive their presence at that hearing, meaning they're not there. So to me, there has to be somebody there advocating on their behalf. Otherwise, that's really just not.
Well, it's obviously a huge due process protection because they do have the right, like you said, they have a right to attend the hearing. They have a right to confront any witnesses or provide testimony. But I know a lot of young adults, because that's certainly the population that I serve, they're terrified to appear before a judge. So, or the court process is overwhelming. And so to also have the option for that attorney to say, it's okay, you don't have to go, is I think also a huge relief.
There's also a second relief, which I really like using, and that's having the incapacity hearing in front of a magistrate. The magistrates really, it's a much, I can't say it's a nicer way to go, but it's a lesser, really a more informal way than the actual courtroom. And I think the magistrates really handle things very well. They're used to that. They have a number of hearings. And I think it's to the point where that really sometimes is a better option, and to have the child present, because you kind of want them to understand what's going on. And yes, it's not a pleasant experience. I can tell you that, it can be a terrifying experience, but in a lot of instances, the judges know that. And
I've had, unfortunately, some of the children and forgetting, different stimuli that might be a trigger, but just walking through a metal detector rather in the courtroom or in the courthouse with bailiffs and, sheriffs, they're not sure all the time if it's, criminal and they're being arrested and being able to differentiate that. So that's where I think that court appointed attorney does have, when you talk about, a lot of power, but it's that power to protect them as well.
Oh, I agree with you. That's where, and it's also just one of the things as a parent that you want to make sure that you get along with the court appointed attorney, that you talk with them, and that you feel that they're acting appropriate, because that's something that's so important. And a lot of people don't understand that. The parents think that they have the power, and they do somewhat as a petitioner, but that CAA, that court appointed attorney, has a lot of power, and it's something that the parents need to understand. And I don't want to say deal with it, but really work with it, I think is the best option.
So Jill, we have the petitioner or the proposed guardian's attorney, we have the court appointed attorney, we have, the examining committee, but at the center of all of this, we have the rights that are being taken away or are in jeopardy of being taken away. So I don't know if you want to talk about that, because there are some rights that this person's always going to keep. I mean, there's some foundational rights that we never take away. And then obviously there are those that are really the subject of this proceeding. So if you could explain that.
Well, there's a couple of rights that obviously can't be assigned. I mean, when you take away the right to marry, clearly your guardian's not going to be allowed to marry for you. You know, the same thing with the right to vote. Your guardian's not going to be able to vote on your behalf. But a lot of times what we really do is there's the two types of guardians. One is a plenary guardianship where all of these rights that we're going to be discussing are taken away. But then there's a more limited guardianship, and those really are the type of guardians that we try and go for, the guardianships, because we try and leave some of these rights with the petitioner, the ward, excuse me. Now the rights that are always retained, and we're talking, this is under section 744, 3215, maximize independence.
Well, and wait, before you go any further, just for those of you that, because Jill rattles these things off,
Sorry.
everybody knows them. She's talking about the actual chapter in Florida law.
Florida statutes. Okay, you like that better? Florida statute.
Well, I always like to joke that, you know, I didn't get a handbook as a parent, but as a guardian, you do. You get this whole chapter in Florida law. So that's the reference that Jill's giving you, just as kind of a side note there. But
and also, I want to interrupt myself for 1 minute. There is actually a guardianship handbook online. The 17th Circuit has it. If you Google it, it's right there. It's fantastic. It was put out by our judges. It makes sense, really details things, and it really gives you a good idea of what's going on. So I highly suggest that you read it if you are in this particular situation. So let's go back to the rights, maximize independence, maximize the possibility of restoration. And that's one thing that Michelle and I are talking about constantly. Yes, this guardianship is forever, but let's say your child gets better, and there's a good possibility, if you have an autistic child, that child somehow later in life really gets a grip and really understands things a little bit better and can be restored. You have the ability to do that. You can always go back to the judge and ask for that child to be reevaluated. And again, I say child, adult, and I have
a quick segue, because we might not have the time to get into restoration.
Also, and that's really where I wanted to talk guardian advocacy.
Well, but I was going to say restoration is an easier process to get rights back than it is to take them away. So just intuitively, it's easier to get a restoration than it is a removal. So just, again, anytime we've got those, you know, new skills developed or whatever it might be, you know, it's always helpful to reevaluate if we could have some rights restored. And
I actually just, I had a young man that wanted to vote, and they had taken his, and he came to me and he explained how he read about Biden, and you know, I went in and I got him reevaluated, and the judge restored his right to vote because he was able to explain himself. So it's something that can be done and should be done. And we constantly evaluate that because you really want to try not to have all the rights removed. So have a qualified guardian, privacy, the right to counsel, which is something we've been discussing, the right to express their preferences. And one of the things that we do as attorneys is we always make sure that if the ward is able to express their wishes, that we make sure that we ask them first. You don't want to be making decisions for somebody if those decisions can be made, you know, by them. Let's see. So let's talk about the rights that are included. And this is really where we want to focus on, because these are the rights that are going to be taken away and in some instances given to somebody else to act on your behalf. So to marry, to vote, to personally apply for government benefits, to have a driver's license, to travel, to seek or retain employment, to own or possess a firearm. And that is a separate one that is actually decided on by the judge during the hearing. To contract, to sue and defend lawsuits, to apply for government, we said to apply for government benefits. How do we get that one? Sorry, to manage property and to make any gift, to determine residence, to consent to medical and mental health treatment, and to make decisions about the social environment or other social aspects of life. Now, I'm going to take a couple of these. Obviously, contract, sue and defend lawsuits, manage property, apply for government benefits. Those are really the ones that you're looking at. When we're talking about a guardianship, there's a guardianship of the person and a guardianship of the property. In a guardianship of the person, you are making medical decisions for that person, or you are making personal decisions. Guardianship of the property, we're talking their money. So when we're talking money, you're really talking lawsuits, benefits. I mean, those major things which are property, those are in most cases, and Michelle can correct me if I'm wrong, going to be taken away from the individual. And you want them taken away because that's really the whole reason why we're here. We want to be able to assist that person to manage their finances, to be able to live their life. One of the things that Michelle said is you really don't want helicopter. You don't want the helicopter parents in there. So you want them to be able to manage their own person in most instances. And I can't tell you that's going to be all of them. But the property is going to be the issue. And that's why those rights are going to be removed. Now, unfortunately, as Michelle and I know, some of the judges get a little removal happy, and they remove sometimes things that shouldn't be. One of the things Michelle and I try and do as attorneys is really advocate to not have the right to vote removed, especially if that person understands. And the second right is the social right. Because if your person understands what's going on, I'm sorry, but the guardian shouldn't be making social decisions for them. They can make their own social decisions.
Well, and Jill, I think to clarify, so when we're talking social decisions, and even to back up a step, these 7 different statements that you just gave, these different rights, these different things, if I'm your guardian, I can control essentially every facet of your life with just those 7 statements. But when it comes to social, it's like what I'm watching on TV, who I'm hanging out with, social media.
And your friends, and that's one of...
Well, and I think this is where for parents, there's a fine line between people that might be harmful or abusive or, you know, those types of relationships where the child is vulnerable. And because perhaps the social skills are not as developed, that is a bigger concern. But as you already said, that doesn't mean we don't allow the child to pick what they want to watch on TV. So even if that right to make social decisions might be removed, I think it still gets back to the guardian allowing that individual to still make some of those day-to-day choices, assuming that they're making obviously safe or appropriate decisions and not putting themselves at risk. So it's always that balance between letting them do some things, but things that, you know, might harm them, and where do we protect them?
I think though, and a lot of people don't understand this, is guardianships are not one all, and you can actually craft the guardianship and talk to the judge. Because a lot of the judges are reasonable, they understand. And so you might say, look, I feel my child might be affected by these particular individuals, and you know, but I don't want to control his video games or his that I don't want to do. The judge could put that in the order. I mean, there's really if the judge wants to, the judge can do what they want within reason. Obviously, I'm not saying do anything illegal, but if they're able to qualify, they're going to do it. I mean, I had a case where the ward's rights were totally removed, but we went to court and the gentleman was allowed to go on a cruise because, you know, even though the guardian wasn't crazy about it, we talked to the judge and the judge felt it was appropriate under the circumstances. So, you know, although we're telling you how restrictive the guardianships they are, when you're in it, you should take advantage, though, of the ability to do things and what you can do within the guardianship. And that is try and personalize it a little bit, because I think that's a really, really important thing to do. All right, so we now have talked about the petition for incapacity. The person's now been declared incapacitated. They have their lawyer. The court-appointed lawyer stays in generally through the filing of the inventory, and we'll get to reports in a second, and the initial report. So that person actually stays in through the incapacity, through the guardianship, and then just hangs around a little bit to make sure things are cool, and then basically stops charging you unless there's a problem. And then they come back in later if they want to. But at least, you know that there's a stop to that lawyer at some point. Now we're at that person's been declared incapacitated. We are now moving into the guardianship. A petition for guardianship, you are basically petitioning for someone to become the guardian of that individual. That person must have an FBI investigation. There is a credit check, electronic fingerprinting, and then a fabulous course given by my compatriot here that they have to take, a few others, but one of the ones who I tell everyone to go take, of course. And you must take this course. It is an 8-hour course. You then get a certificate. It's an 8 hours course, and you get a certificate at that point, and you must file that certificate with the court. You must file everything with the court.
So I think it's important to remind parents that just because they're the parents doesn't mean they automatically qualify. So,
well,
you know, I mean, you mentioned about the fingerprinting and the background screening, even the credit check, which I always tell clients, it's not like the court's looking for a particular credit score.
Well, no, but I'm not into it, but I was getting to that because I've had clients that have applied and their credit was too low. They forgot to tell me about that bankruptcy they had a little while ago. Oh, whoops,
or that felony they forgot about.
Felony. Oh, I forgot. Oh, you know, I just forgot that I was arrested and I went to jail. I just didn't remember. Or that, you know, needless to say, Michelle and I could go on with stories forever about this, but what we're trying to get across is you may not be appointed. Again, mother and father fighting with each other, you're not getting appointed. Then the judge is clearly going to put in what's called a professional guardian, because the judge is going to want an independent person in there. So, you know, I always tell fighting parents to try not to fight, because I'm really sorry, but neither one of you is going to wind up with the guardianship. And that's something to really consider too. I didn't mean to interrupt you.
No, that's okay. So I was going to say, you've got the qualification piece to even just get appointed. Then once you're appointed, you've got to file some initial, and we'll talk about even annual reports to the court. And then you've got to take the class within 4 months. So when we talk about this court supervision on an ongoing basis, I think you kind of get your taste for it in the very beginning when you've got to jump through all these hoops. And again, it doesn't matter what that family relationship is. You know, this is Florida law and the judges are going to enforce it. And so if they say you're jumping through these hoops or else, you're not going to be appointed if you don't do it. And likewise, and I know we don't have the time to necessarily go into all the different reasons for this either, but you can be removed as the guardian of your own child.
Oh, yeah.
So if you're not complying with court orders, or you can be held in contempt, I mean, there are a whole host of other things that can happen. But this gets back to the courts taking this legal relationship very seriously, even if you are the parents. And it's not to intimidate or to scare you. It's just that you understand that this is an individual that's the most vulnerable in our state with their rights removed. And the court has a duty to protect them, even if it's from bad family members. So, you know, just that was kind of where I was headed with making sure that you understand, you know, that not just anybody off the street is going to walk in and become the guardian just because they say so.
No, and the judge has no problem with removing you or if you've done something wrong. And one of the things I also have to counsel the parents, do me a favor and please don't tell the judge, well, I'm the parent, because the judge is going to go crazy on you. The judge doesn't care that you're the parent. The judge wants to hear, I care about my child. I want to do the best for my child. That's what the judge wants to hear. And every single time when I have parents that are thumping, I have one gentleman who does pay for his son, and he keeps telling the judge, well, I'm paying for everything. And the judge is, the judge basically almost held him in contempt the last time. He was furious at him. You have to be very, you're in a courtroom, and you must be respectful of that judge. That person is the one who's making decisions for you. To me, I wouldn't want to be crossing him. And even as an attorney, I try not to cross him or her, because number one, I'm obviously going to appear before them again, but I want the best result for that particular person. So to start messing with the judge is something that is just not appropriate, and something that the parents really have to understand. Even though you're the parent, he's the judge. And that's the issue in the guardianship. If everything boils down to it, that woman or man sitting, I'm sorry, I have the transgender too. I don't want to let anybody out, but that person sitting up there is the person making decisions for your child. And the quicker you get that, the better off you're going to be.
So we've already talked that guardianship is obviously invasive. It can be expensive. Obviously we've got this ongoing legal relationship.
Oh, look, should we?
What are pieces we missed?
Wait, let's talk cost right now, because that's important. So, hi, Michelle. I want a guardianship for my child. How much is that going to be?
It depends.
Bingo. And that's, it's the two words that nobody wants to hear. But the unfortunate part about this is I can't give you an answer. Okay.
Well, the only thing we can control is like the filing fees.
Oh, yeah.
Some of those hard costs, we know what those are.
Almost $2,000. Like, and people are like, well, I go the 2,000. Oh, that's the I go, no, that's just the court costs. I haven't discussed with you the legal fees yet, because you have almost $800 in filing fees alone, and then you have close to $1,000 in examining committee member costs.
Well, and that gets back to if the state doesn't pay for them. So let's still pretend the state pays for those.
Correct.
But you still have filing fees. You've got the fingerprinting. You've got, the background fee to the court conceivably. You've got the class. I mean, the hard costs alone just to get to, your appointment and then a little bit is probably easily $1,000. And that's in costs that we can't make go away. And it has nothing to do with the attorney's fees. It has nothing to do with if families are fighting, then legal fees are always worse. So, obviously the answer, it depends. I know nobody likes it, but it can start out from something minimal to something, exorbitant, depending on the circumstances.
And the other issue too is now, we're petitioning. Well, I don't know what the court appointed attorney is going to do. And I've had cases, I've had great court appointed, and then you have court appointed that rack up the fees, which is a huge problem. The court, the one thing we can tell you is in Broward County, the attorney fee is capped at $350 an hour. That is the most an attorney can charge. And the paralegal is at $125 an hour.
Well, unless they get an exception from the judge.
Yes, but there is an administrative rule that states those. And yes, you can get an exception from the judge. It's fairly rare. If there's litigation, you're going to get an exception because obviously that's a whole different situation. But generally, a plain vanilla guardianship, you're not going to get that. Let's discuss the other little thorny issue. Are mommy and daddy getting paid if there's money in the guardianship? No. I'm really sorry, but the judge is going to tell you exactly what he's going to tell me. This is your job. This is your kid. You chose to have this kid. You're not getting paid for it. Are there instances where the parents get paid? And the answer is yes. However, those are multi-million-dollar guardianships where the parents are actually managing money, doing things. Really managing properties. If the parents are doing things like that, they will get paid.
Well, but Joe, let me clarify here. So likewise, sometimes a guardian can be reimbursed for certain expenses.
I'm not talking reimbursed.
No. But the parents' fees that you're talking about, or these reimbursements for that matter, are taken from the assets in the guardianship. So I just want to be very clear that if somebody doesn't have any money, you're not getting paid anyway. And there's not some sort of pot of state of Florida money that pays guardians. No. So I just want to clarify that if the guardianship itself does not have assets, nobody's getting paid.
That's correct.
No, okay.
You got that one.
So what else on guardianship? Because I know just trying to watch our time a little bit, and we still have to cover guardian advocacy so that everybody understands the differences between those two.
Okay, so let's say we got the guardianship. Once you get the guardianship, whoever is appointed, you now have to file an inventory. You have to explain to the court what's in the guardianship. You then have something called an annual report, where every single year you have to report to the court the mental state, what they have, their medical, how much is being paid, where they are, if there's hurricane preparations, if they have a care plan, all of their rights, should their rights be restored. What else am I forgetting? There needs to be a doctor's letter. This is if you received any remuneration as the guardian. So if you got paid anything, if you made, well, some people make appearance fees or any of those things with their children, that has to be reported. What else? What am I missing?
Florida law tells us obviously what has to be in these reports. Every circuit has a little bit different, format that they like. So that's where the attorney is going to come in to help you supervise and oversee to make sure things get done timely and accurately as well. So,
but I want to be very clear on this. These reports are your responsibility, not the attorney's. The attorney is responsible for filing them. The reports are the guardian's responsibility. So one of the things that you want to do is you want to make sure that you've got a file with the statements in there, with everything that you know, if there's rental income, any of those things, you want to make sure that you have documentation, whether it be paper or Dropbox or anything like that. As the guardian, you are required to keep that and have that documentation. And it's very important, because when your lawyer says to you, here's the plan or here's the accounting, you need to be able to answer that and not say, oh my God, I didn't realize I had to keep that stuff.
Well, yeah. And likewise, tracking all the doctor's appointments, even if the person's in a facility or a group home. I mean, you as the guardian still have to know who's touching their body. So, I mean, those are the sorts of things that obviously documentation, but we could talk about that for a whole nother day too. But it's critical. It makes or breaks, you know, how well the guardian might survive those annual reports.
That's actually, and one of the other things that you need to understand, and then I'm going to be quiet because I really want you to get into guardian advocacy, which is an alternative to guardianship, is that if you file the report and the court doesn't like it, you will then get a fun letter that says order to show cause, that you have to appear before the judge, because guess what? They don't really like the way you did the plan, or there's a problem, or an auditor added a few numbers and he didn't like that. So you're constantly under scrutiny and you need to support everything. So like Michelle says, document, keep everything. But one of the things, and I want to stop because we are running out of time, I do want to show the alternative to what a guardianship. Obviously, we've shown you how intrusive this is, that it is expensive. We've shown you other alternatives, but now let's show you another alternative that is a viable alternative. And I'm going to turn it over to Michelle to talk about guardianship advocacy.
Well, and that's where I think you have to understand guardianship before you can understand guardian advocacy, because you have to understand the restrictiveness before we can talk about taking away some of those pieces. So a guardian advocacy falls under a little bit different chapter to start with, and that's chapter 393, but then it basically says, follow all the rules of chapter 744. So there's kind of an overlap between the two, and that's where there tends to be some confusion. But where a guardianship can be used for any sort of incapacity, so someone that might have a brain injury or a mental health diagnosis, or certainly, you know, dementia, guardian advocacy can only be used for certain developmental disabilities. So we are talking about an intellectual disability, someone that also has cerebral palsy, autism, spina bifida, Down syndrome, Prader-Willi, or Phelan-McDermott. If we don't have one of those diagnoses, we're not even talking guardian advocacy. So we have to start there. And where the process is a little bit different is that instead of sending out the examining committee to do all these evaluations to determine that this person is incapacitated, you as the petitioner are going to submit the evidence to the court that this person has a developmental disability. So normally that's by way of an IEP or a TIEP if you have a transition IEP. Yes,
and I'm stopping you for 1 second though. And here, let's tell, what is the most important difference between a guardian advocacy and a guardianship? Does a lawyer need to open a guardianship advocacy?
Maybe. It depends. So
but the answer
we'll get to that. We will get to that.
The answer though is no, but, and that's the.
It depends. So I'm still sticking with it.
Okay.
So
yes, boss.
Ultimately, you as the petitioner, again, are submitting this evidence to the court. It might be an IEP, a TIEP. It has to show that developmental disability, that diagnosis. It also could be some sort of neuropsych evaluation or even something from the pediatrician that just shows that we had this diagnosis prior to the age of 18 and it meets the requirements under this section. You submit that evidence. There's still a hearing, but what's a little bit different between the two is one, we're never going to have an order determining this person is legally incapacitated. So we basically just accept the diagnosis as their disability, which I have to say, as a sibling of someone with Downs, I'm not really crazy about that theory because everybody presents very differently. They have different strengths and weaknesses, but yet we kind of lump them all together in the same category that says if they can do some decisions on their own, and that's another kind of big qualifier in the statute, and it's a gray area for attorneys to debate all day. If they can do some decisions on their own, but they need some support with other decisions, then we're talking guardian advocacy. But just on the basis of this diagnosis, that's how we kind of move forward. We still have a court-appointed attorney, so they're still representing the individual through this process because we're still taking away rights. But we're not talking about any of the personal rights, like Jill mentioned, the right to vote, to travel, to work, to drive. All of those are left intact. We don't touch those. And some parents get a little nervous about the right to marry still being left intact. Again, people make bad decisions about marriages all the time. But those are the sorts of things that we're trying to encourage a level of independence by leaving some rights alone. We allow the person to keep those rights. We are only talking about the other 7. So the contracting, suing and defending, managing property, government benefits kind of get lumped in there. And certainly the personal decisions, the residence, the social, and the medical and mental health decisions. But we're never going to have a court order that says this person's legally incapacitated. You are going to have a court order that says a guardian advocate's been appointed, and these are the rights that they've been given. So sometimes where there's some confusion is in the rest of the world because they don't understand what that means if this person still has capacity, but yet they lost some of their rights. And that's where that legal paperwork's really going to be critical to show somebody, what this person can or can't do for themselves. But so we don't have the examining committee. We don't have a petition to determine incapacity. So likewise, we don't have the order determining the incapacity. What Jill's talking about is no attorneys required for that petitioner if, and here's the big if, the only rights that you're asking for are those personal rights that include the right to make the medical or mental health decisions, to determine residence, or to make those social decisions. And the court goes another step further to include government benefits and educational decisions in that grouping. In that particular case, you do not have to have an attorney to get this started, although you can choose to have one. You can also start with an attorney and they can withdraw later on. So it can look like whatever you want it to be. But if you're concerned about cost, obviously you don't have to have an attorney to start a guardian advocacy of the person. So again, those personal rights. Where some parents, and Jill, this is where it gets back to it depends for me.
I understand.
Some parents are concerned because through the school system, credit card companies are coming out and actually doing solicitations for pre-approved credit card offers. So that falls under contracting or even property. Sometimes they're concerned that their child's going to go out and, lease a car or sign something that maybe they shouldn't, inappropriately. And where I've sometimes seen it come up, and this is again one of those unfortunates when parents are fighting, is when it comes to child support beyond the age of 18, and that child is then named as a party in a lawsuit. So now we need the guardian advocacy to have the right to sue and defend. So there are those circumstances where sometimes a guardian, or rather an attorney for that guardian advocate might be appropriate to get it started. So again, we're trying to go that route whenever we can to keep expenses down. We're trying to keep as many rights in place or intact as we can. So there are obviously pros and cons to both guardianships and guardian advocacies. And what I want to do, just in the event that we run out of time, I want to throw it out there now before I forget, and then you and I can continue to make sure that we didn't forget anything, is I helped create, in conjunction with the Florida Justice Technology Center, a website for this very purpose, because quite honestly, I got tired of answering the question when it would come up. But the website is turning18.org. So it's the word turning, TURNING.
Can they post that in the chat? I know
it's also on the resources page.
Okay.
But we don't have access to the chat, so they can't. Okay. But it's the word turning, the number 18.org. And basically it discusses all the options that Jill and I were just talking about today. So it talks about estate planning documents and supported decision-making. It talks about guardianship. It talks about guardian advocacy. It is not intended to replace legal advice, but it's for those 2 minutes that you have to yourself in the middle of the night when you want to start looking at what those options are. It's intended to be educational. But if you decide that a guardian advocacy of just the person is the route that you want to go, it'll actually help you populate the forms in each different circuit, as well as helping you be directed to local legal resources. So, again, that website, it's not the be all end all, but it's ultimately something to just get some of that basic information. If an hour of listening to Jill and I didn't, get you to start thinking about some of these things, then we've got the website to fall back to as well. So I just wanted to make sure, Jill, that I threw that out there. I know we're kind of coming up on the end of our time, and want to make sure that if we have other things that we missed, that we still discuss. I do want to point out with the guardian advocacy, some of the other things that are similar. We still have filing fees. We still have fingerprinting. We still have taking the class.
We got the judge.
Initial reports. So those don't go away.
Yeah, yes, and you're absolutely correct. It's somewhat kinder and gentler. I mean, that, you know, at least it's a way for parents not to have to go through the entire system and really the indignancy of the examining committee. And to piggyback on Michelle's resource, the 17th Circuit, which is Broward County, has a fabulous website dedicated to both guardianship and probate, but there's a lot of guardianship resources on there for you to be able to look at. There is also the elder law section of the Florida Bar. They have their own website. You can Google it. And there's also resources on the elder law section's website, all on guardianship and guardianship advocacy. Did I miss anything?
I don't think so. So I think, again, though, to summarize, is we've got resources that are out there. I think if we change the conversation, and I've tried to do this even within the school system with some of the ESE specialists, you know, we don't start with guardianship. It's not a, when are you getting a guardianship? It's a, when are you looking at the legal options at 18? And then is estate planning, guardian advocacy, or guardianship kind of going up the different levels there? Which one's appropriate for this child? And it's not one size fits all. And obviously all of these, whether it's a guardian advocacy, we can have restoration of rights. Obviously in a guardianship, we can have restoration. So it's not always a one-way street. But obviously making sure that as a parent, as a family member, there is something in place to protect this child until they have developed the decision-making capacity is really the key. And I know, Jill, you and I are also big proponents of making sure that the parents have their own affairs in order. Because ultimately, if something happens and the parents pass, and let's say that child does not have legal authority, you know, from anywhere else, then somebody else is scrambling to put something in place. So for the parents to do their own estate planning, naming those successor guardians or those successor agents, and certainly Colette and Melissa momentarily will be talking about special needs planning. But, you know, those are the sorts of pieces that the parents have to think about. Well, what about when I'm not here? If my child isn't in the system, so to speak, what is that going to look like?
And that's a terrific segue into both Colette and Melissa, because one of the other things, obviously, in consideration with what we're discussing is when the parents are doing their planning to worry if their children as adults are in the system, on Medicaid, on any other type of government assistance, that if they left them money, they would be thrown off of that. So clearly I'm not going to go into special needs because I know that Melissa's going to do that, but it's something with estate planning that the parents really need to look at. And when you go to your estate planning attorney, it's something that you need to discuss with them. It's very, very important. You know, a lot of times when they fill out that intake sheet, the parents aren't thinking about that. And it's really something that I want parents really to think about.
Well, and I think it's the whole family dynamic, because I think grandparents forget to think about that sort of planning, and certainly aunts and uncles. And so
can we just get let's at least get the parents. I mean,
I know, but I can have big dreams. So, you know, those are the sorts of things that I know, you know, Jill and I just threw a lot of information at you. You know, again, we've got the resources that we left with Dorian. I don't see any questions for us to have to entertain right now, but I know either one of us would certainly welcome any questions in the future. And Dorian knows how to find us if that's the case. But I want to go ahead and just, you know, say thank you again for your time and attention. This is certainly a wonderful way to try to honor Arlene. And ultimately now we were going to go ahead and turn it over to Colette Small. She's an attorney here in Florida as well, along with Melissa Barnhart, also another attorney. So you got a bunch of attorneys this afternoon. So we will turn things over to them to talk to you about special needs trust and some of that special needs planning that kind of continues that discussion as parents.
Absolutely.
What do we need to worry about, and, you know, planning for our child's future. So Colette and Melissa, it is all yours.